Hey everybody, Jonas Callis here of the Hurt at Work Workers' Compensation Law Firm. Many of you know me as the Workers' Comp Guy. First, the obligatory disclaimer. The following information is for informational purposes only and does not constitute legal advice to anyone, nor does it create an attorney-client relationship with anyone. So, marketing. If you have a workers' compensation claim, or you know someone who does, you've probably heard the term marketing, and it probably hasn't been in a positive context. So, what exactly is marketing? In the Virginia Workers' Compensation Commission, marketing is just another term for job search efforts, really. But you know how lawyers and legislators like to use fancy words and legalese to make things more complicated sometimes than they probably need to be. So instead of putting it in terms that people can understand. But legally, in the context of the Virginia Workers' Compensation Commission, marketing is just the requirement that an injured worker who has been released to perform some sort of light duty or modified duty work, sedentary, light duty, medium duty, even heavy duty, so long as there are still work restrictions, that worker must actively market his or her residual work capacity. So what does that mean? If you think about that for a second, all it means is, has the injured worker sufficiently looked for potential jobs within his or her doctor-issued work restrictions? That's it. It's just a job search effort, right? It's a job search effort corresponding to whatever work restrictions that worker has. So now that, and it's really not complicated. So now that you understand what it is, why is it important? Why is it important? When does it matter? Typically, when somebody gets hurt at work, most of the time the injuries are worse right after the accident, right? So a lot of workers are held out of work by their healthcare providers, right? If they're held out of work at all, a lot of times it's right after the accident happens, right? And then, presumably, the way a lot of these claims go, they start receiving medical treatment, and the whole point of the medical treatment, and usually it works, is to get the injured worker better, to heal those injuries and get the worker back to where they were before the accident, okay? So as they go through that process of receiving medical treatment, physical therapy, and drugs sometimes or whatever, they start getting better, and the doctor, their doctor or doctors eventually release them to return to either full duty work or some sort of work with work restrictions, all right? The distinction of whether an employee has been released to full duty work or work with some sort of work restrictions or completely held out of work is an important one. Well, why is that? Because an injured worker whose doctors have held him or her completely out of work, they said no work, right? No work for right now, no work until your follow-up, no work for 2 weeks, et cetera, et cetera. A worker who has not been cleared to work in any capacity has no duty to market, no duty to search for any sort of jobs because there are no work restrictions. Like, you're not supposed to be working. You can't work. You can't work if you're not supposed to work pursuant to your doctor's orders. So that's the first requirement in terms of marketing in the Virginia Workers' Compensation Commission. It's that the injured worker must have been released to return to some sort of modified duty work, or whether it's sedentary, light duty, whatever. Now, once the worker has been released to return to work, obviously injured workers should let their employers know. In fact, really, an injured worker who's still working for that employer should kind of constantly, there should be, if possible, and it doesn't always happen. Some employers act funny towards workers who are hurt at work, but many employers, you can maintain an open communication channel. And to the extent that that still exists, injured workers should constantly provide communication, updates about, well, my doctor is still holding me out of work. Here's the work note. If you have the record, here's the record. Give them a copy of the record or ask them to make a copy and give it back to you. That way they're completely up to date and they know what's going on with your treatment and whether you can work or not. This is important because some employers, particularly larger employers, can actually they have enough positions within their company or whatever where they can actually provide some sort of light duty work to accommodate the injured worker's work restrictions. So the commission believes that in being fair to employers, if the employer can provide that injured work, and it's fair, I guess it's fair to workers too, because they can start getting back into the swing of things, right? They want the worker to return to work. That's really the goal. So to the extent the larger employers can, and some smaller employers can too, I guess, but usually that's the issue, is a lot of smaller employers, they only have 4 jobs anyway, they can't accommodate work restrictions. They just don't have light duty work. They need everybody at full capacity. But larger employees can sometimes offer light duty work to the employees, and they can return to work even though they're still kind of recovering and working to recuperate from their injuries. When the injured worker has been released to return to work with restrictions, doesn't have any sort of award order or judicial opinion awarding temporary total disability benefits or temporary partial disability benefits, and he either does not have a light duty job or is not earning the money he was earning prior to the work accident. And I know that's a lot, but in that scenario, he may have a duty to market his residual work capacity if he's seeking temporary total disability benefits. A lot of times that happens earlier in the claim, right? Maybe the claim has been denied initially. So the worker has filed the claim for benefits seeking. They're saying, hey, my doctor held me out of work, why aren't you paying me benefits, right? So the injured worker will file a claim for benefits seeking temporary total disability benefits, okay? So he's not on an award yet, he's trying to get one. Not on an award yet, there's no opinion yet because they haven't had a hearing. And he's not working because his doctor has held him out of work, but for whatever reason, maybe the employer doesn't think the accident itself was compensable, so no benefits should be awarded, right? Well, in that situation, if the employee, the injured worker, eventually, say 6 weeks in, the doctor releases the employee to return to sedentary work, right? Well, from that point onward, the injured worker is released to return to some sort of work. So at that point, the injured worker has a duty to search for jobs that require only sedentary work, right? Because that's the injured worker's work restrictions, all right? So contrast that to the scenario where the injured worker already has an award or a judicial opinion awarding wage loss replacement benefits, or where he has already found a light duty job where he's earning as much as or more than he was earning before the accident, right? Well, if you think about that, like logically, if you're earning, even whether it's a light duty job or not, if you're earning more than you were earning before the accident, where's the wage loss? There actually is no wage loss, right? You've gained somehow, right? It's rare, but it happens. So if there's no wage loss, you can't have wage loss replacement benefits, right? So in that scenario, the injured worker has no duty to market his residual work capacity. No duty that means, again, no duty to conduct any sort of job search, right? So those are some scenarios where the injured worker may have to conduct a job search. And so it's not just conducting a job search though, right? Like there are actual standards, right? Like it's really what the defense that employers and their workers' compensation carriers will raise quite often is that the employer or that the employee did not conduct a sufficient job search. So what does sufficient mean, right? What standards make a job search sufficient or not sufficient? According to the Virginia Workers' Compensation Commission's marketing guidelines, and I'm summarizing here, a sufficient job search, and I guess the first and most obvious requirement is that it requires an injured worker to submit job applications to at least 5 potential jobs each week. 5. Okay. Now, take note because in certain situations, right, there are claimants who are trying to get workers' comp benefits, but they were also fired for some reason or whatever, and they're also trying to seek Virginia employment or unemployment benefits from the Virginia Employment Commission, right? The Virginia Employment Commission requires a job search of 3 per week, right? So that's different. It's not That's sufficient. 3 is sufficient in the VEC, but 3 is not sufficient in the Virginia Workers' Compensation Commission. 5 is the number. Okay, so that's important. So what jobs do you have to apply to? Well, you can't apply. If you send a letter or an application, to be the starting running back for the Washington Redskins while you have a sprained knee or something, right? Like, that's not a sufficient. There's no way you're going to get that job, right? So that's not going to count. They have to be jobs that are, we've talked about this, jobs that are within your work restrictions. Okay, so if you have a work restriction that says no lifting and carrying over 15 pounds and must be allowed to take a break every hour if he needs one. Okay, it has to be jobs that can accommodate those work restrictions. Those are the jobs you have to. So you have to apply to 5 jobs each week that can accommodate those work restrictions. All right, and it's a job. It has to be jobs that the worker reasonably believes that he can work and that he can get and work. Okay, so if you're applying to a job in Idaho and you live in Virginia, that's not going to be sufficient. It needs to be in your geographical area, and it needs to, you need to be able to get to it, et cetera, et cetera. Okay, so it's just kind of common sense, but they are requirements that those are things that the employer and their workers' compensation insurance companies will pick apart at a hearing. Okay, so you need to, at a minimum, meet those requirements. And quite frankly, as mysterious as the topic of marketing is in the Workers' Compensation Commission, that's really all there is to it. It's not that complicated. It's just that people say marketing instead of job search efforts, and that really throws a lot of people off, understandably, because a lot of people aren't legally trained. So one ninja tip I wanted to add, actually. When you're submitting job applications, that can become an issue at trial. Quite often, employers and workers' compensation insurance companies, their attorneys, will raise the defense that the employee has not sufficiently marketed his or her residual work capacity. Okay? So at trial, you need to provide evidence of that. Well, just saying, yeah, I applied to 5 jobs per week, that's pretty weak evidence, right? So your best evidence is to actually keep a log of your job applications, right? And it's really best to keep a log of each job you applied for, obviously, the employer to whom you applied, the physical requirements of each job, the date the application was submitted, how the application was submitted, the contact, if you had like a HR contact or a general manager or something, the contact for that employer for that job, if there is one, and the result of the job application, and any other such details that you think are relevant, right? That'll help you remember, right? If you keep a job log like that, that's really good evidence at a trial, because you can say, yes, I did apply. I tried to apply to at least 5 jobs each week. Sometimes I went over, and here's a list of all of them. I kept a list. So that's very strong evidence, and usually the commission will accept that. Now, the one thing I'll say about that, this is kind of an addendum to the ninja tip. If you're trying to keep a log, that's awesome. That's perfect. That's the way to go. However, it's going to be really hard to create the log retroactively, right? Because there's some, like I just mentioned, there are some details that you want to include in a job search log. So if you try to wait 6 months, 8 months later, and then go back and retroactively create it based on your memory, that's never a good idea, because you're going to forget a lot of the important details. You want the details. The details are what make it credible evidence, okay? So you really want to do it on a daily or at least a weekly basis. That way you can recall all the jobs the jobs that you submitted applications for. So that's it. That's all I got. That's all I have to say about the marketing requirement in the Virginia Workers' Compensation Commission. Thank you for watching my video. I hope it's been helpful. For more information, check out my website. It's www.hurtatworkinva.com, and that's www.hurtatworkinva.com. Has a lot, it's chock full of information. The whole point of the website is to provide information to injured workers, information that may be hard for them to gather on their own, and it'll help them kind of get their bearings and maybe be able to kind of represent themselves, or at least know what's going on with their workers' compensation claim, okay? Additionally, follow us on YouTube, Facebook, Twitter for informational videos like this one. There are a lot of topics that I've covered, which again, designed to be helpful to injured workers. They're kind of educational. If you found this helpful, and hopefully you have, if you found it helpful, then chances are others that you know would find it helpful. Okay, friends, family members, and so feel free to share it, right? Because even if you're not hurt, maybe they get hurt at work and they need the information, or maybe they know someone who was hurt at work and they can be like, hey, check out this website. It's got a lot of good facts, and you can maybe kind of manage your claim and at least not fall into the tricks and traps of the insurance companies. Okay. I used to work for the insurance companies. I did the insurance defense. I was the one doing the tricks and traps. I know what they are, right? So I tried to convey those on the website, and I try to convey them to some extent on the videos with my ninja tips and so forth. So, in my mind, it's the reason I did the videos and the website is it's better to have the information and not need it than it is to need the information to have your claim be successful and not have it, right? It's always better to have that information, even if you never even need it. That's all I got. Until next time, stay safe and don't get hurt at work.